an unprecedented case, a appointment of a judge in the Madras High Court has now been challenged before the Supreme Court of India. In a twist, however, minutes before the matter was mentioned before the bench headed by the Chief Justice, the Government of India issued the notification appointing l.n. Victoria Gowri as an additional judge of the Madras High Court. Her appointment has raised several eyebrows, particularly in the Madras Bar, which has questioned her affiliation with a particular political party. In fact, Chief Justice of India D.Y. Chandrachud has also remarked in open court this morning that certain information was made available to the collegium after the recommendation was sent. The bench has agreed to hear the matter tomorrow, that is Tuesday. We're being joined by Senior Advocate Sanjay Hegre on this matter. So this seems to be a very unusual, unprecedented matter. How exactly does the law look at this? Can, now that the notification has come, what is the legal provisions open for the petitioners, and especially since the court has also agreed to hear it?
See, it's not an unprecedented situation. Way back in 1992, if I remember rightly, there was a gentleman called K.N. Srivastava who was appointed and the notification had come in, but before he could take oath, there were judicial proceedings.
Okay.
This court, by a judgment of Justice Kuldeep Singh, went into the matter and thereafter said that he was ineligible to hold office because he did not have the requisite qualifications. So a person is not a judge until he or she has taken the oath of office. That has not yet happened here.
Okay.
Secondly, this notification appoints the person concerned as an additional judge. An additional judge does not have the protection of being removable only by a process of impeachment. There have been instances where additional judges have not been continued as judges. There have also been instances where the appointment notification has been cancelled before the person takes oath. So I do not think it is entirely unprecedented. Secondly, I wish to say that I am not commenting on the merits of this particular candidate. I am only telling you about the procedure.
Since this morning when this matter was mentioned, Senior Advocate Raju Ramachandran mentioned the matter. He had also cited this 1992 case where the appointment of a
judge to the Assam High Court
was in fact later cancelled by the Supreme Court.
Yes.
But in that situation, sir, the qualifications of the judge were under challenge. Here, the issue is regarding the petition, at least, that has been filed, that mentions the speeches that have been made, the fact that the conduct of the judge, the speeches made by the judge, the articles written by her make it so that she would violate. It is the apprehension that she would violate Article 15 of the Constitution. But Mr. Ramachandran had taken the stand that this is about eligibility and not suitability. How do you see this line of argument in the
Yes,
court?
Mr. Ramachandran is a very good lawyer and is a precedent-oriented lawyer. And the original precedent in Srivastava's case spoke about eligibility.
Okay.
Now, eligibility has many facets, including the fact that if somebody has expressed very strong views,
okay,
sometimes that also becomes a disqualification. You must remember in the United States that the nomination of Justice Bork by President Reagan was opposed by people in the Senate on ideological grounds, and ultimately the nomination did not go through.
In India, however, sir, we've seen very recently the Supreme Court in the case of two judges, nomination of two judges, has specifically said that any articles written or tweets or social media posts prior to taking oath of office cannot be counted, because that is what the collegium resolution
cannot necessarily be held. An occasional tweet or a post cannot necessarily be held against them.
Yes, sir.
But if there is a long pattern, and if there is any other information, we do not know.
Okay.
So, right now, this matter is being looked upon on the judicial side and not on the administrative side. I would not venture to state anything as to how the case will go.
Okay.
I have only told you the procedure of where people, despite a notification appointing them, still did not finally make it to judicial office.
All right. Thank you very much, Mr. Hegde, for explaining this to us. We were speaking to senior advocate Sanjay Hegde, who is saying that in a situation like this, there are precedents where the appointment of a judge has been stopped prior to them taking oath. What will happen in this particular case, we'll have to wait and see. In New Delhi, this is Aneesha Mathur for India Today.